The practicing criminal and civil lawyer, who is also a senior lecturer at Royal Institute and Sri Lanka Law College. We warmly welcome you, sir, and we are pleased to have you here today with us. Without
Thank
further
you for
ado,
having me.
I shall end with ensuring that this discussion will be a fruitful one. Thank you very much.
Thank you.
Good evening, sir. Thank you for being with us this evening.
It's my pleasure being here, Zina.
This project aims to educate the general public, where we look at the issues and then we look at how people can resolve the issues, and most importantly, to educate the public of our legal framework. So we aim to simplify the laws. And let's begin today's discussion with consent. What does consent mean in the offense of rape? And what types of consent will not be accepted in the court of law?
Yes. Before I commence with the consent, just give me just 2 minutes to go on the basis of what sexual offences that are included in the Penal Code of Sri Lanka. We have rape under Section 363. We have the offence of incest under Section 364A. Unnatural offences under Section 365, acts of gross indecency under Section 65A, grave sexual abuse under Section 365B, and sexual harassment under Section 344. So these sections will indicate offences which can be taken into the definition of sexual offences in Sri Lanka. Coming into the question that you asked me, Zina, to be very honest, if you really go through the section which basically defines the offense of rape, the very definition itself, or the very act of rape, the actus reus will be sexual intercourse with a woman, a man having a sexual intercourse with a woman without the consent of that woman to indulge in that sexual intercourse. So, prima facie, the absence of consent is a vital element in the offense. Consent can also be obtained, but nevertheless, as you asked me the second part of the question, nevertheless, it would not qualify as a consent due to various other reasons. For example, if you take the instance of a person who is under lawful or unlawful detention and you use force to obtain consent, such a consent would not be consent in terms of the law. If you have obtained consent by intimidation, that would not be consent under the law. By threat of force, or putting the person in the fear of death or hurt, would amount to a consent that has been obtained by fear, also by duress, if you can use the word. So those types of consent will not qualify as consent for sexual intercourse. On the other hand, you will also have consent obtained from a person who is intoxicated, and the person has been made intoxicated by the perpetrator or by a third party. Also, in a situation where the person is unable to give consent because the person or the victim is of unsound mind, in such a situation, such consent would not qualify as legal consent under the law. Also, we have instances where sexual intercourse is indulged by people who are unable to consent for sexual activities by reason of being underage. For example, the age of consenting for sexual activity in Sri Lanka under the law is the age of 16. If you're below 16, then even if you have consented, that would not qualify as a consent. So, broadly speaking, consent would not be consent under those circumstances. I believe that is an answer to the two questions you asked me a little while ago.
So in essence, consent should be of free will from the individual.
Absolutely right. It should be free will, genuine consent, understanding, appreciating what kind of activity she is getting into is contemplated prior to granting that consent.
So could we go on to explain what passive submission and consent
Yes, I
are
could.
and the difference?
Yes. In doing that, I would also make use of a particular judicial decision, Inokhagalage versus Kamaladararachi and others, which is reported in 2002 SLR, Volume 1, page 307. And I like to basically take you to a particular quotation from the judgment, because the Honorable Justice Asoka de Silva, at the time his lordship was in the Court of Appeal, has delivered this judgment. And in page 311 of the judgment, his lordship quotes a particular quotation from Rao Harinarian versus State, where Justice Tek Chand, an Indian justice, had said, and I quote, "A mere act of helpless resignation in the face of inevitable compulsion, quiescence, non-resistance, or passive giving in when volitional faculty is either colored by fear or vitiated by duress cannot be deemed to be consent as understood in law. Consent on the part of a woman as a defense to an allegation of rape requires voluntary participation, not only after the exercise of intelligence based on the knowledge of the significance and moral quality of the choice between resistance and assent. Submission of her body under the influence of fear or terror is no consent," unquote. I go into the judgment of His Lordship Justice De Silva, where he says, when a court is confronted with the situation where the victim says that the act was done without her consent, and the accused takes up the position that it was done with her consent, then consent becomes a matter of inference to be made from evidence of previous or contemporaneous acts and the conduct and the attendant circumstances. In considering the question of consent, it will also be useful to refer to the question of consent is by far the most important in the case. Of course, such consent may be express or implied. It is an express consent, a case will be seldom taken to court. If it is taken to court, it will have to consider if such consent was likely to have been given by the prosecutrix. Excepting, of course, the case of prostitutes and other mercenaries, women are seldom prone to translate their thoughts in these matters into words. They usually leave the matter of consent to tacit understanding. In such a case, consent becomes a matter of inference to be made from evidence of previous or contemporaneous acts and conduct and other surrounding circumstances. In deciding a case of alleged rape of a girl, evidence showed that the girl left home with compulsion. She journeyed with the accused from place to place. She never complained of any ill treatment by the accused to any of the people she met. And there was only her evidence that alleged sexual intercourse was without consent. As per that case, I'm saying, it was held that in those circumstances indicated that if there was any sexual act, it was with her consent. Bottom line is, very clearly, the question of consent is defined as express and implied consent. And very clearly, you could see that passive giving in is clearly distinguished from express or implied consent. Permit me also, Zainab, to refer to another case where His Lordship Honorable Justice Cicero Diabru, presently a Justice of the Supreme Court, Honorable Justice of the Supreme Court, when His Lordship was in the Court of Appeal, delivered judgment in a case CA 93/2005. Judgment was delivered on the 6th of July 2007, where His Lordship, I quote from the judgment. In the judgment, it is said, in the instant case, following matters will be relevant in deciding whether the sexual act was performed with or without the consent of the prosecutrix. And His Lordship laid down 6 particular points derived from the facts of the case, where His Lordship decides whether consent was there or not. First one, medical evidence did not corroborate the testimony of the prosecutrix. Number 2, washing the blood stains of the clothes by the victim. Blood stains in the surround was not produced as evidence. Delay in making a complaint to the police. If there was prompt complaint and if the story of the prosecutrix was true, the doctor would have found fresh injuries. The delay in making a prompt complaint to the police has negated the opportunity of fresh injuries being found by the doctor. It can be argued that she delayed the complaint being made promptly in order to avoid the emergence of the falsehood of her story. 5th, the love affair between the prosecutrix and the appellant. And 6th, the appellant was in the habit of visiting the prosecutrix in her house. These are all circumstantial evidence which clearly lay down whether there was consent or not. In this case, from the above matters, a reasonable doubt is created on the question whether the sexual intercourse was performed without her consent. So considering all the matters, we are of the opinion, His Lordship says, that the prosecutrix has failed to prove the fact that the act of sexual intercourse was done against her will or without her consent. So obviously you could see the distinction between passive submission and consent, and even with regard to consent of express or implied, as let's say with regard to implied consent, certain evidence, which is probably not direct evidence, but circumstantial by all means, in cumulative effect, would either establish consent or the absence of it. In this latter case, it was established the absence of consent. Did I answer your question, Zainat?
Yes, sir. The next question is, according to Sri Lankan law, is there a possibility where a woman can be held accountable for committing rape on a man?
It's a very good question, especially in this era. But if you really look at the definition under section 363 of the Penal Code, it's predominantly, or if I may use the word, it's very much clear that the offense is contemplated as being perpetrated by a man on a woman. So therefore, in the context of that definition, I don't think, this is my opinion, I don't think that envisages a rape by a woman of a man.
Is rape within a marriage a crime in Sri Lanka, sir?
That's also a very good question. That's also a very, very good question, because according to the contemporary criminal laws, marital rape as a concept is criminalized only in the event of judicial separation under section 363, actually 363A. If you look at it, it says, without the consent, even where such woman is his wife and she is judicially separated from the man. So reluctance on the part of the drafters and also the legislators at the time, probably in 1995, to include marital rape in all circumstances had really brought, if I may use the concept of marital rape only within 363 A. This restrictive approach is also it's also influencing the Prevention of Domestic Violence Act of Sri Lanka, Act number 34 of 2005. If you want to make a further reference onto the issue, because it defines domestic violence as all offences contained in Chapter 16 of the Penal Code, where marital rape in all circumstances has not been recognized in our law, except in the circumstances where the person is still married, but yet there is a judicial separation and the act of rape occurs during that period, but still within marriage. So very limited, I would think, is it included under Section 363. Maybe because it's also I'm not in a position to criticize the law. I'm just in a position to say, when you really read the Hansard, or when you really read the comments of the drafters at the time, they have indicated that the legislators at the time were really not proactive in admitting the lock, stock, and barrel of the concept of marital rape, probably because of the cultural stereotypifications in our land.
But sir, marital rape is recognized internationally, isn't it?
It is a concept recognized in many jurisdictions, I would think. I agree with you. And I think maybe with time, the thinking, the stereotypification might also change. And I think the idea would be that certain elements of this offense will have to be explained to certain quarters of our lawmakers, especially the legislators, I would think, because they're the people who will be going back to their electorates to justify it to their people, their supporters, and to their electorate. From the field of law and experts in the law, I think the concept does exist. But whether it has manifested as in law in Sri Lanka, because we can see the barriers. But I agree with you, it is a concept in certain jurisdictions in the world, yes.
So could we enlighten the public on the punishment for rape, the crime of rape?
Yes, I could. Yes, I could. With regard to rape, if you really take the offense of rape, you could see the offense of rape having the following punishment. Whoever commits rape, it says, Section 364, shall, except in the cases provided for in subsection 2 and subsection 3, be punished with rigorous imprisonment for a term not less than 7 years and not exceeding 20 years, and with a fine, and shall in addition be ordered to pay compensation of an amount determined by court to a person in respect of whom the offense was committed for the injuries caused to such person. Now, there is a minimum mandatory sentence clearly laid down there. So it is very important for us to understand it spans from 7 years, not exceeding a period of 20 years. So I also want to say, or take the opportunity of saying, the following. This concept of minimum mandatory sentence was discussed in an important case decision. Also, later on, after passing the act, this issue was taken into consideration before the courts of our land. And I would like to basically cite the case of Rohana Elias Loku versus Attorney General, reported in 2011 to SLR, page 174, where His Lordship Honorable Justice Gamini Amaratunga, Justice of the Supreme Court, at the time deliberated and held that, citing an earlier case, that is SC reference 3/2008, it's the Anuradhapura case, His Lordship said, I quote, the unanimous opinion of the court in that determination was that the minimum mandatory sentence in section 362(2)(e) is in conflict with Article 4(c) and 11 and 12(1) of the Constitution, and that the High Court is not inhibited from imposing a sentence that it deems appropriate in the exercise of its judicial discretion, notwithstanding the minimum mandatory sentence that has been laid down in, of course, in this case, section 260, 2E in that determination. But in this particular case, what I'm citing is Rohana Elias Loku. His lordship went on to state, basically taking the facts of the case into issue. The accused was technically found guilty because actually the accused and the prosecutrix had an affair. And you could also see that if you read the case, the facts of the case was such that taking the facts into account, you could not give him a custodial sentence. And the court wanted to exercise the discretion because the facts of the case was such that a custodial sentence was not demanded. So his lordship delivered judgment saying the accused is technically guilty of the offense described in section 364 2E of the Penal Code. However, upon considering the facts of the case and the submissions of the counsel, this is not a case where the accused has to suffer a custodial sentence. So although there is a minimum mandatory sentence, the Supreme Court has found that the minimum mandatory sentence does not prevent the very important functionary of a judge, which means the discretion of granting or deciding the punishment based on the facts of the case. In other words, that has never been taken away from a judge. Therefore, that discretion was given to a judge in terms of SC reference 3/2008. Thereafter, Rohana Elias Loku versus Honorable Attorney General, and also thereafter, Her Ladyship Honorable Justice Iva Vanasundara, Justice of the Supreme Court at the time, in the case of the Attorney General, Honorable Attorney General versus Mudyan Se Samantha Sampath, which is SC Appeal number 17/2013, decided on the 12th of March 2015, also went on to decide that this minimum mandatory sentence was against the Constitution. Any mandatory minimum sentence imposed by the provision of any ordinary law, in my view, in Her Ladyship's view, is in conflict with Article 4C, 11 and 12 of the Constitution, in that it curtails the judicial discretion. This is the important part of it, judicial discretion of the judge hearing the case, because it's very important that the judge who hears the case, who feels the case, who listens to the witnesses, looks at the demeanor and the deportment of the witnesses, should have the discretion in sentencing the convict once he is found guilty. So therefore, even though the punishment is such, and there is a minimum mandatory sentence, it is important to understand the judicial discretion relating to that has not been taken away. It's all common law decisions which has strengthened, if I may say, the bare skeletons of the Act or the Penal Code has been supplied with flesh and blood by those judicial judgments or judicial decisions that have emitted from our higher courts. That would be my answer to your question, Zenith.
Thank you, sir. Could you explain what institutional rape means? Because a lot of people might not understand what it can.
Yes. Institutional rape has also been identified, if I may say, as a species. If you look at section 364, subsection 2, where the punishment for rape is being given, where whoever, being a public officer or a person in a position of authority, takes advantage of his official position and commits rape on a woman in his official custody or wrongful restraint and commits rape on a woman, or being on the management or on the staff of a remand home or other place of custody established by or under law, or of a woman or children's institution, takes advantage of his position and commits rape on any woman, inmate, or such remand home, place of custody or institution. Being on the management or staff of a hospital, takes advantage of his position and commits rape on a woman in that hospital. Commits rape on a woman knowing her to be pregnant, etc. So all those instances where I have said institutionally, or where it has been emphasized that where a person is in a position of authority in an institution and the victim is institutionalized, and if the person rapes a victim in such an institution, that would qualify as an institutional rape, and the punishment would emit from the point of view of the rape being committed by a person in authority in such an institution.
So could you educate the public on what grave sexual abuse means?
Yes. Grave sexual abuse is an important offense because we have seen the offense of grave sexual abuse coming before many of the courts. Section 365B defines what it is. Grave sexual abuse is committed by a person who, for sexual gratification, does any act by the use of his genitals or any other part of the human body, or any instrument on any orifice or part of the body, or any other person, being an act which does not amount to rape. It doesn't amount to rape, right? Under the section 363 that I've just mentioned. In circumstances falling under the following: without the consent of the other person, or with or without the consent of the other person when the other person is below the age of 16 years of age, with the consent of the other person while such other person was in lawful custody or unlawful detention, when that consent has been obtained by the use of force or intimidation or threat of detention, or by putting such person in fear or death or hurt, with the consent of the other person where such consent has been obtained at a time when the other person is of unsound mind, or for in the state of intoxication induced by alcohol or drugs. Whoever who commits grave sexual abuse will be punished with rigorous imprisonment for a term not less than 5 years and not exceeding 20 years, with a fine and also with compensation. So that is the definition of the offense of grave sexual abuse. Remember, grave sexual abuse needs to be identified with the element that it is not rape. It is by no means rape. It is lesser than the offense of rape. And also, Zeenath, may I also say now that you mentioned the offense of grave sexual abuse, Honorable Justice Tureraja, Justice of the Supreme Court presently, when his lordship was a Justice of the Court of Appeal, delivered a judgment in the case of Ratnayaka Mudyanselage Bandula Padmakirti versus the Honorable Attorney General, where his lordship said, in our criminal law is well established in recognizing the right of an accused and ensured of a fair trial under the supreme law, namely the Constitution. When a person is charged, it is mandatory to provide him with a clear charge sheet under a valid law. When a person is charged, he should be aware of the charge and the ingredients of the charge. Then only he can prepare for his defense. When a person is charged for rape, he cannot be convicted for grave sexual abuse because the ingredients are different to each other. If he is convicted, that will attack the root of the concept of fair trial enshrined by the Constitution. So that clearly makes a distinction between the two offenses. Merely because you don't have enough evidence for rape, you cannot convict the person for grave sexual abuse if that was never framed as a charge. So His Lordship Honorable Justice Tureraja, as a Justice of the Court of Appeal at the time, has delivered this judgment, which I think is very important for our listeners to understand the distinction between these two offenses. I hope I answered your questions, Zeenath.
Yes, sir. Moving on, sir, we have gang rape as opposed to the act of rape. It's a general perception that rape occurs between two individuals, but in case of gang rape, it can occur between many individuals. And there are also instances where only one person actually commits the rape, whereas the other people help that person to commit the rape. So in such an instance, how does a law punish people who help the individual to commit
I
a
think
crime?
that's a very, very good, very good question. Well, if all the participants who are accused of gang rape have, according to the evidence, participated in the act of gang rape, then of course they will be charged under certain sections of the penal code read together. If they have participated, evidence is such, then I believe they will be convicted if the evidence has been established beyond reasonable doubt that they did participate. But coming to a very important point that you raise, that if there is one or few of the people who are accused who have merely been present and who have not actively participated, and their participation is not a participatory, or if I may use the word, I think I should correct myself, if their presence is not of a participatory nature, then such a person will not be found guilty of gang rape. I'm also going to refer to a case, Honorable Attorney General of the Democratic Socialist Republic of Sri Lanka versus Madhubange Don Dinesh Danushka Jayawardena and Chiran Hasanta Balage, CA 81/2010, decided on the 28th of November 2017. His Lordship, Honorable Justice Tureraja, presently a Justice of the Supreme Court, at the time Justice of the Court of Appeal, where Her Ladyship, Honorable Justice Devika Dilivera Tenekon, agreed in this particular judgment. If I may go into one part of the judgment, the above evidence on record show that the second appellant was not involved in the act of rape. The evidence really revealed that he was with the first appellant and nothing more. To convict a person under section 364(2)(g, there should be some evidence of abetment being proved. But in this case, there is no evidence against the second accused appellant, and he had told the first accused to let her go, within inverted commas. Therefore, we conclude that there is no incriminating evidence against the second accused appellant. Accordingly, we quash the conviction and acquit him from the charge. So there you are. If it is an instance where you don't have a presence which is actively participating, then it's merely a presence, then you would not be found guilty of gang rape.
So that basically means if you do not contribute to the committing of the crime,
and you don't have the intention of actively, or not active, you don't have the intention of participating in the offense. Actually, if you really look at that particular piece of evidence, the second accused had said, let her go. So when he says let her go, the mens rea of that person is actually not the mens rea that should be there of a person who is committing gang rape.
Absolutely.
He's got no intention to commit harm on the victim.
So could we explain what gross indecency means?
Sorry, I couldn't hear you.
Could we explain what gross indecency means?
Yes, I could. Gross indecency is also an offense that is coming under section 365A. Any person who in public or private commits or is a party to the commission of, or procures or attempts to procure the commission by any person of any act of gross indecency with another person shall be guilty of an offense and shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Remember, in here you could see gross indecency is something which can be committed in public plus private. So if a person misbehaves grossly indecently, for example, exposing himself in public and acting in a manner where it is against the norms of decency under the law, then I think that would come within acts of gross indecency. So I think in a situation where these acts of gross indecency is concerned, if you go through the cases that have been decided on that, various instances have come across, and maybe it would be exposing your genitals or private parts in public, or behaving in a nature which would be contributory to something like that, would be, among other things, coming as gross indecency.
Thank you, sir. What is incest, and what is a punishment attached to incest?
Yeah, incest is actually where sexual intercourse is between parties which have been defined to be related, descendants from one another, or is adopted parents or adopted grandparents, adopted grandchildren, or you have a relationship of either being siblings or being a half sister, half brother. This has been laid down under section 364A of the Penal Code. Remember, these sexual relations between these parties are criminal, and they would be found guilty of incest, where they would be punished under the law. Whoever who commits incest shall be punished with rigorous imprisonment for a term not less than 7 years and not exceeding 20 years with a fine. Remember, Zainat, when you talk of incest, you need to talk about the prohibited degrees of marriages that are also laid down by what is identified as the Marriage Registration Ordinance. No marriage shall be valid where either party shall be direct descendants from the others, etc. And it has given any marriage or cohabitation between parties standing towards each other in any other manner enumerated degrees of relationship as enunciated in this act. That is, I'm talking about the Marriage Registration Act, which is also talking in terms of the provision of 364A, will be an offense and shall be punishable with imprisonment as mentioned in the Penal Code. So obviously it is also a prohibited degree of marriage, and also any sexual act between these parties would be incest. So there you are.
Thank you, sir. Let's move on to the victim. How is the victim protected within our legal framework?
I think that's a very, very good question that you have asked. When you talk about victim protection, we need to talk about very clearly the victim protection that has been available since lately. And we have to talk about the Assistance to and the Protection of Victims of Crimes and Witnesses Act number 4 of 2015. This is a comprehensive act which relates to victims. If you talk about victims of any offense, if you talk of victims of incest or sexual offenses, they too are covered by this particular act.
In the event a female becomes pregnant as a result of rape, can she have an abortion, and what relief does such a victim have?
Well, abortion in that sense will be under section 303. Remember, the section says, whoever voluntarily causes a woman with child to miscarry shall, if such miscarriage be not caused in good faith, for the purpose of saving the life of a woman. That is the basis. If it is endangering the life of the victim, then abortion shall be permitted. I know there have been a lot of literature that has been available, saying that the law needs to reform itself. It's up to the legislators. But if you really phrase that question on the basis, can she obtain an abortion under the Sri Lankan law, under Section 303? She can obtain if that is going to endanger her life. Now, that's something that needs to be clearly emphasized, because clearly Section 303 clearly lays down that under the Penal Code.
Thank you, sir. How does our legal framework support the victim of a rape to move on to a normal life? Because it scars them, and also the social pressure. So how do we have a framework of support?
I think if by chance she happens to give birth to a child of that nature, and the victim and the perpetrator is convicted of the offense of rape, let's say, in such a situation, under Section 28 of the earlier said Assistance to and the Protection of Victims of Crimes and Witnesses Act number 4 of 2015 allows the trial judge to award a compensation, and the limit of the compensation has not exceeding 1 million. So a substantial compensation could be really granted in the instance where the person has been convicted to the victim. At the same time, if the person is going to bring up the child, she could claim maintenance for the child from the perpetrator. But I don't think those are perfect circumstances. Nobody would be wishing that upon anybody. I'm just talking about the remedies that are available. But having said that, I think social stigmatization is something still prevalent. And I think Sri Lanka still is not really looking at a man and a woman from the kaleidoscope of equality from a social perspective. Law has, but from a social perspective, I think there needs to be an attitudinal change to this. Because if I may say, recently we've seen in the media news coming out about a particular beauty contest. And in that, the question of a single mom has come up. I don't want to talk about the beauty contest, but I'm trying to say, how do people view single mothers? How do people view a woman having a child, let's say, without a father? I think the stigmatization is very detrimental, and I think it's time that we change these attitudes, because I think we should not traumatize a woman who is already traumatized, not for her own fault, but because of the fault of somebody else. So I think greater leeway has to be given, and our attitudinal changes must be made.
Absolutely, sir. Sir, can a rape victim claim damages?
I think so. The rape victim can, because if you really go through this particular section, that is Section 28 of this particular law, Section 28 subsection 5 says, the receipt of compensation by a victim under the earlier said provisions of this section shall not prejudice the victim from claiming damages in any civil proceeding, provided that when determining the quantum of damage to be awarded, such civil court shall take into consideration the compensation received by such victim under that section. So she can claim compensation in a civil court, but in granting compensation by the civil court, the court will take into consideration this compensation granted under Section 28 of the Assistance to and Protection of Victims of Crimes and Witnesses Act number 4 of 2015. So that says you can, or that indicates you can.
Okay, sir. So now we move on to the question and answer session. So prior to this event, we've circulated a Google form online where people can send us questions. And based on those questions, we've received a couple of questions. And one person asked, if you see or hear a person being raped or likely to be raped, what actions can be taken?
I think the most important thing is if you can get assistance from other people to make sure that the rape doesn't continue and to sort of stop it without causing much more harm to other people around, I think that's the first thing that you should do. But immediately notify the law enforcement agencies and call for support from the law enforcement agencies to ensure that the perpetrator can be taken away from that misery.
Also, so there's another question. How do you define date rape, and what can be done about the extraordinary number of women who still choose not to report rapes by their friends and boyfriends?
I think date rape also would fall into a situation where, let's say, I mean, if by chance in the process of this particular date, the woman has been intoxicated, then it clearly comes within the definition of rape. But bottom line is, whether it is date rape or otherwise, rape is rape. So I think the offense of rape is very important. It covers all these segments, and therefore it lays down a punishment which is fitting. And I think it is applicable to any sort of rape that is envisaged under that particular section. The second part of your question, as I said earlier, stigmatization is a social issue, and we need to overcome that by merely changing our attitudes. Not only the attitudes towards rape, but the attitude of looking at women entirely. We don't really look at women, or let me correct myself. We don't look at the ideology of a woman as somebody who is merely there to assist the male species in the process of continuing life as an equal partner. We instead has a society which looks at women as a sexual apparatus, if I may say, which brings pleasure to them to the men. So long as we have that attitude in us, stigmatization will continue, because a man can indulge in this kind of activity and still talk about it, and a woman who has been the silent sufferer cannot talk about it, because for obvious reasons she will be stigmatized by society. Look at the basic example. We tell our boy child, you can have many experiences as you want, because the more experiences you have makes you a better man. But look at the way we look at the woman. We say you have to be virtuous. You have to be, somebody who should be protected, so that, your virtuousness is something valuable to the society. There you are. So how would you deal with that other than an attitudinal change?
Also, there's a question. A girl was raped when she was 13. She didn't tell that to anyone, but now she's 19 and wants to take action against the man who raped her. Can she take action?
Well, I mean, if she has a reason for her to explain why the delay was for so long, I think her police complaint can be taken as a complaint, and then investigations can be comments. But she'll have to give reasons why the delay, you see, because the delay can be for also reasons which will benefit the defense in that case at that time.
True, sir. There's another question. Does it matter whether a rape is a stranger rape or an acquaintance rape in the eyes of law?
I couldn't follow that. I'm sorry.
Does it matter whether a rape is a stranger rape or an acquaintance rape in the eyes of the law?
I don't think it matters at all. If it is a rape where your consent has never been given for the sexual activity and you have been forced upon, I think it doesn't matter what scenario, what circumstance it happened, actually.
True, sir. There's another question. What are the rights of a rape victim if the offender gets found not guilty? Will the alleged victim be called a liar or get arrested?
No, we look at it from the point of law. If a person has been acquitted of the offense, then that person has, in the eyes of the law, been acquitted, and he is not the person responsible for any rape charge or any rape that has been alleged against. In such a situation, if a woman is being called a liar, I don't know what sort of remedy she would have, because if she's being called a liar, Well, I mean, her allegation has not stood the test of evidence before a court. So I don't call her a liar. I don't encourage people calling anybody liars. It's just that her allegation has not been proved beyond reasonable doubt. In that instance, the person is acquitted and the person is innocent, and the charge is merely a charge, has not been proved beyond reasonable doubt. So I'm unable to answer the question about liar because I think that is very circumstantial.
True, sir. There's a simple question. What is statutory rape?
Good. Statutory rape is where the victim is less than 16 years of age. In such a situation, whether you had the consent of that person or not, it doesn't really matter because the person is not capable of giving the consent because she's underage. So therefore, all what you need is to establish that she's less than 16 years of age and the fact that rape actually happened, because it's a very, very, very important thing to note that a person less than 16 years of age is not capable of consenting to sexual activity.
Also, sir, this is one of my personal questions with regards to women,
Yes.
a woman raping a man. Even on an international
Yes.
scale, even though we have a set definition for rape, is there a possibility where a woman can rape a man if the definition was not set?
Well, it's
On
a
an
very difficult
international
question to
arena.
answer. I mean, I appreciate your question, but it's a very difficult question to answer. Well, I think the concept of rape should equally apply to genders from a point of view of genders. But I think the modus operandi obviously will change. So therefore, having the offense of rape for a man raping a woman will have to be sort of suited for a woman raping a man. So the factual circumstances will be different. So it's a very difficult question to answer, Zeenat. I would think, like in many parts of the world and jurisdictions, this is an offense that is spoken about. We'll have to wait and see whether time will bring that offense as identifying, crystallizing into an offense under our law.
Thank you very much, sir, for answering all our questions.
It's my pleasure. It's my pleasure.
Now we move on to the vote of thanks.
Yes.
So thank you very much, sir, for the very fruitful session. On behalf of the Law Students Association of Sri Lanka Pro Bono Committee, I would like to thank you, President Counsel, Mr. Seevali Amithirigala, for sparing his valuable time of his schedule to enlighten us and the public on this much needed topic. And also we would like to thank you for being patient and supporting us throughout this whole session. And also we would like to thank you, our audience, for being an active audience and asking questions. So yes, that's it. So I wish you a good night and
Good
thank
night.
you.
Before that, please permit me just 1 minute. Thank you so much, Zeenat. Thank you, all of you. I've been a lecturer in law for the past 18 years. As you said, patience is a virtue that a teacher must have. And it was my pleasure. Let me congratulate you for all the attempts and endeavors in trying to expand academia among young law students and the public. So thank you. Thank you for having me today. It's been my great pleasure.
Sir.
Thank you.